everyone. The session is live, so you can start if you'd like.
Good afternoon, everyone. My name is Christine Bliss, and I'm the president of the Coalition of Services Industries. And we're delighted to have the opportunity to meet with all of you today and to share the views of our very distinguished panelists on services innovation. The future is digital. Today, we're going to be talking about the interface between innovation, regulation, and trade in an effort to build a better ecosystem to support growth in industries around emerging technologies. For example, cybersecurity, AI, fintech, and regtech. This may involve new rulemaking in the WTO or in RTAs, as well as new approaches to aid for trade capacity building efforts. The session draws on the experience that collectively our panelists have had in both RTAs, WTO, and also in their private sector and academic experience. The panel also explores in particular, as an example of this, the ways in which policy issues intersect with trade policy, especially regarding the development of standards, and in particular, digitally enabled services standards. In addition, we've provided to those in the audience a copy of the recent T20 paper that was done to really contribute to thinking about where the gaps are in digital policy and where we might develop new disciplines or take other actions. I want to introduce our very distinguished panelists today. We're going to be hearing first from Rupa Chanda, who is going to give us, as a backdrop, trends in digital protectionism, and she's done extensive work in the Asia Pacific region, along with other areas in the globe, and the ways in which it creates hurdles for the growth of services innovation, particularly looking at areas such as possible imposition of duties on e-commerce and other concerning trends that may undermine the ability to innovate and promote emerging technologies. Rupa is professor in economics at the Indian Institute of Management in Bangalore, but she is currently on leave right now, and as the director of trade, investment, and innovation in division at UNISCAP. Our next panelist is Dr. Jed Horner, who is currently the head of government relations and advocacy for Stone & Chalk, where he looks at policy settings for critical and emerging technologies that enables companies to scale sustainably and securely. Prior to this role, he led and was the strategic advocacy manager for Standards Australia, where he authored Australia's AI standards roadmap. So Jed will be taking a look at the work that he's done, and particularly on AI, and the need for further work on digitally enabled services standards. We will next hear from Eunice Huang, who is head of Asia Pacific policy for Google. She, and in particular, with a focus on WTO. Prior to her current role, she spent over a decade in Singapore's Government Administrative Service, working on a diverse set of issues ranging from foreign policy, energy policy, trade policy, and economic development. So she has extensive experience in that regard. And we're going to hear from Eunice in terms of her thoughts of where she sees the biggest barriers to digitally enabled services in the landscape, and what she sees as perhaps most promising in terms of the T20 paper recommendations. And last, we're going to hear from George Riddle, who is Director of Trade Strategy at Ernst & Young. He has more than a decade of experience in international trade. And at Ernst & Young, he is primarily responsible for advising multinational corporations on their trade strategy and Brexit readiness. Prior to that, George spent over 6 years representing the United Kingdom at the World Trade Organization. And so George will also be giving us his views on the T20 paper and their specific recommendations. So with that, let me first turn things over to you, Rupa, to give us maybe a backdrop and to start the conversation. And after we have remarks from panelists, we're going to have open it up to discussion among the panelists, and then we'll look at questions that we receive from the audience. So over to you, Rupa.
Thank you very much, Christine, and thanks for this opportunity to share my views. So, it goes without saying, we know that today cross-border movement, storage, and use of digital information has become really critical for trade and production. Not only MNCs are relying on these flows of data for their operations, but you also have MSMEs, startups, and less represented segments of the economy that have started integrating with global markets and GVCs using digital platforms. And we've also seen in the last 2 years with the current pandemic that this has just accelerated this transition to a digital economy and reliance on online delivery. In fact, recent research that I did in the Asia Pacific region showed how you have small sort of fintech startups and retail startups and so on, which have really emerged with in terms of integrating with the global markets and using opportunities to understand consumption trends. And so digitalization is really opening up a lot of new opportunities for business innovation, new verticals and niche areas where many of these enterprises are getting into. So digitalization supported by data flows is becoming a key feature of new business models, and obviously then the policy environment surrounding cross-border data flows and digital trade regulations more generally, that becomes very important. So what we're seeing in the landscape now is that increasingly, we're seeing more and more regulations that are restricting these flows to address a variety of objectives. You have cybersecurity, national security, industrial policy related objectives, and they're taking many forms. I think they're growing like anything. You have local data storage and processing requirements, you have discretionary approvals as well as bans on data exports, adequacy determination requirements, which you have country or region specific technical requirements and standards, which are often not transparent, don't align with international standards. You have restrictions on electronic payment systems. Then, of course, infrastructure and connectivity issues, data privacy requirements, local presence related conditions. So you name it, you really have a plethora of things, some in the realm of domestic regulations, but also those at the border. And if you look at just the number of measures that have been taken with regard to data localization measures, the numbers increased from 19 before 2000 to more than 70 by 2017. And today there are more than some 200 data regulations in place today. And the key issue here is that you are having growing regulatory divergence and incompatibility among countries at a time when businesses, companies large and small, need to rely on the seamless flow of data and need interoperability of standards and systems to realize economies of scale and scope and to be competitive. So there's the risk of discrimination, increased trade costs due to regulatory compliance burden and fragmentation of markets. For instance, if you take data localization requirements, having to store your data in a server, now that may not just be cost effective for a small startup or an MSME, and having access to overseas, lower cost data servers might be much more profitable for them. And this might actually be an entry barrier for them to get into global markets. So non-conforming requirements for digital services across countries, which aren't based on international standards, can really affect the ability of firms to provide goods and services efficiently and competitively. Basically, it's resource allocation wise, it's distortive and can lead to suboptimal business plans and operations. And the burden is likely to be greater on the MSMEs and the less experienced exporters, which, as I said, could be an entry barrier. It could thwart the emergence of new enterprises because they would find it much harder to navigate these restrictions. And these unilateral measures will also lead to more business uncertainty, higher prices, higher costs, and less variety. And this is one thing that we often don't we always look at it in terms of the protection of the producer, but the impact on the consumer and the effects on consumer welfare, prices, and variety is something that's sort of lost out because consumers are many and producers are a sort of known lot. In light of this acceleration that we've seen in digitalization of businesses and the uptake of digital transactions by consumers, which has really opened up new opportunities, it becomes very important, I think, to address these emerging challenges. And looking ahead at MC12, this is going to be one of the key issues. So what really, I mean, if I look at the range of things that are important here, I've talked about data localization. There's the moratorium on e-commerce, which again, whether that's going to remain or not is a key concern. So let me focus on the e-commerce moratorium in particular. Because as we know that, this is something that was adopted by the members in 1998 and has been extended every 2 years. But this has become a bone of contention with some developing countries questioning the need to extend it further. And they've called for structured discussions on scope, definition, impact, etc. Now, just to lay out what are the points of contention, right? First is the issue of definition, whether the electronic transmissions refer to the device or the content. And so one set of countries is referring to the content of digital trade. And so the tariff ban would apply to the digital content. While other countries are interpreting the transmission as referring to the device which carries the content, so you can put customs duties on the digital content. A second area of difference is that while one set of countries wants a permanent moratorium to give more certainty to businesses and consumers, another set sees the moratorium as causing revenue losses. I would say the fiscal aspect is perhaps the one that's been highlighted the most to the neglect of many other factors. And the idea here is that the argument is that there's a growing number of products that are getting digitally traded. So something you could not foresee when this moratorium was first implemented. And so countries like India, South Africa, Indonesia have raised this point. And the third point of contention is that having a permanent moratorium would really restrict these countries from protecting domestic products and services that are traded online. It will stifle the growth of a nascent industry. So a sort of infant industry protection sort of argument is being laid out. Now, how do we unpack this debate? I think it's very important to look at the validity of some of the arguments that have been placed. And this is where it's a little disappointing because, there are studies which I don't think are on very firm ground on this. If we consider the costs and benefits of trade disciplines, especially the moratorium on customs duties and the issue of tariff revenues foregone, you have to see that there are conceptual, methodological, and practical issues there. So if you take the methodological thing, first of all, we don't really have a good handle on what the potential loss in revenues is. So the debate itself sort of falters on that ground. The estimated impact ranges, if you look at the studies, anywhere from $280 million to $8 billion. If you use a narrow definition, then it's a very small percentage of government revenues. It depends on whether you use average MFN rates, bound rates, etc. So the range really is sort of ambiguous. And so we're arguing on the basis of something which rests on certain assumptions, which may or may not be valid. In fact, I mean, if you take a very large proportion of things as becoming digitizable in future, then too, taking applied rates, you don't get a very big revenue loss. And then if you make assumptions about, many things like in 3D printing taking over the future of manufacturing, that too is really not applicable. So I would say that, this is not on very firm ground, the sort of estimates that we've seen on revenue losses, and much more empirical evidence would be required to make a strong case saying that we are really having foregone revenues because of the moratorium. The second is the practicality of imposing tariffs on electronic transmissions, because there are a lot of technical challenges with this. You really don't have applicable duties. You don't have the right kind of regulatory systems. You have constraints in digital and physical infrastructure. And just the practicality in terms of measuring where the data is coming from, what is the value that's being generated, where is it being generated when you have things coming from multiple servers and then coming through different routes, different jurisdictions. How are you going to allocate the value share across the different jurisdictions and then assign some tariff to it, if at all a tariff could even be created for it? And the concept of digital goods is very different from goods trade. You can't really apply like a rule of origin or certificate of origin for the source of transmission. So I think there's a practicality issue that on which this whole argument on removing the moratorium sort of falters. A third, I think, which is the more important one, which is the broader debate on the effects of digital trade taxes on the economy. If we just put one side, which is the revenues, potential revenues, which can actually be substituted with alternate sort of forms of domestic taxes. But there's the larger impact, potential adverse impact on domestic enterprises, on consumers, due to higher prices, higher costs, stifling of innovation, stifling of new sort of business models and ventures, the impact on value addition as a result, and therefore again on domestic taxes. There are the enforcement and compliance costs and the resource allocation inefficiencies I talked about. You're also likely to see a disproportionate effect on certain sectors and types of enterprises. And it's also possible that it's not just going to be on digitizable products, because with growing servicification of goods trade, some of it will also fall on digital services. So, and on the other hand, we know that there are many positives that would kind of get undermined. Digital trade helps in reducing trade costs. Imports of services are very important for exports. So a lot of digitally enabled services like business support services, and this is an area actually, if you look at mode 1 trade for developing countries and imports of services, under mode 1, it's business and professional services that are growing very rapidly. So that, and these are actually feeding into the export competitiveness of these countries. So therefore, in a way, by stifling imports through import substitution policies, you'll also be undermining your own export potential. And there's also evidence, if we see, especially following the pandemic, how digital technologies like web pages, digital delivery have allowed firms, MSMEs, to find new markets and so on. And again, you'd be affecting them by duties on electronic transmissions. Their ability to integrate would be affected. So these kinds of gains, the possible adverse effects, and the methodological and practical difficulties really suggest that we need to kind of revisit this whole argument about lifting the moratorium. And the larger effects on development, the costs on productivity, output, employment, export competitiveness may be far larger. Instead, you need to look at non-discriminatory alternative means of taxing the digital economy. And for that, you need a conversation. Perhaps WTO is not the right forum. We have other organizations which are looking into this. And that's where countries need to participate. I'll just end by saying that, there are valid concerns, though, that have been raised. And I don't want to completely, naysay those, because there is the issue of how you make digital companies pay their fair share of local taxes, and how this could be addressed through, say, cooperation in the OECD's global tax framework, or through equalization levies or significant economic presence tests. So one has to look at alternatives, but this has to be placed within the larger discussion on regulating anti-competitive practices of big companies, which could prevent smaller companies from benefiting fairly from the digital economy. So I think there are certain valid concerns. And the second one I would say is about whatever negotiated outcome comes from the joint statement initiative. It has to, the e-commerce debate has to be linked with the larger development objectives. And that's where I think the work of various groups like the MSME group under the work program, or issues of capacity building, these areas need progress if really to tie the development of e-commerce or the digital economy with larger development purposes. I'll stop here and I can talk later about what we need to do going forward. Thank you.
Thank you, Rupa. That gives us a lot of, well, first of all, it was an excellent backdrop for the discussion today. I gave your overview and then specific comments on areas such as the e-commerce moratorium, and putting it in a broader context was very useful. So now I want to turn to Jed Horner for his comments, and we're going to dial in and look more specifically at the issue of services standards, specifically digitally enabled services standards. So Jed, over to you.
Thank you so much, and really am indebted to Rupa for those comments as well. I think they were a fantastic overview, as you said, Christine, as we lead into this discussion. What I wanted to focus on today was to move away from some of the development and taxation discussions we had just a second ago, and to paint a picture about what we're seeing in the global standards landscape as it intersects in terms of the regulation of digital trade and services, and then to walk us through a few glimmers of light, rays of light, if you will, as to how we can tackle this challenge globally. So I think many of Rupa's comments I sort of associate myself with and endorse too. I think what we're seeing globally, and that is, including in countries such as Australia, countries that would describe themselves certainly as middle powers, is the tension between, as you mentioned, Rupa, those tendencies to regulate domestically increasingly around issues like cybersecurity, national security, and to invoke those interests to legitimate domestic forms of regulation. Clearly, in spaces in which I work in and in which our economy is deeply invested in, with the growth of digital services in areas like fintech, that can pose challenges, and we're just beginning to see rays of that. So examples of domestic regulation in the Australian context we're seeing are around cloud hosting that is focused on the domestic context, and essentially designing new frameworks for companies operating here. That is a live discussion. Other measures proposed, in fact, now before our Parliament, are on the basis of cybersecurity concerns and involve step and intervention powers that are actually unprecedented globally for many multinationals too. So we've got very practical examples, not just in the global south, but also indeed in countries like Australia, where we are grappling in really tangible terms with the challenges you spoke to. And I think that's important for people to bear in mind, that we're seeing this behavior globally, indeed in our own backyard. So when we talk about it on the global stage, I do want to be very honest in sharing those stories as well. I think we've seen, however, some really positive developments where standards as technical tools and enablers have played a key role in helping to level the field in terms of interpretation, particularly for SMEs, for fintechs, for companies working, in a cross-border sense, which in the digital space, as we know, is most of the constituents we work with. And there an example is the International Standard on Privacy, which came out of ISO, it's 27701, which looked at leveling the field and actually making the requirements of GDPR more interpretable to businesses. What we did in Australia through a domestic exercise here was then to say, how do we take that architecture that's been designed globally with our colleagues in Europe and actually make it applicable here? So that's accessible to SMEs, it's accessible to businesses, multinationals, as a common architecture, if you will. And those are some of the technical fixes we are seeing to, I think, the divergence of regulation and approaches globally. And the example there, of course, was the divergence in terms of privacy regulations. So we had the EU approach as a block. We've got the situation with the US where they have a very different approach to privacy, state-driven, with only 3 states in the mix there with those frameworks that codify those requirements. And then indeed with Australia with its own domestic requirements. But we know that there's been frictions in terms of cross-border data flows created by the delta, the void in those requirements and those legal frameworks. So we do have models of working across borders globally where standards can work, international standards through recognized standards bodies can work to actually smooth the path for businesses of all sizes. What they also then lead into in a very practical sense, and many people on this call will be familiar with this, is inclusion in regional trade agreements, the digital trade agreements which New Zealand and Chile and Singapore have entered into, or indeed the agreements between Australia and Singapore in that respect, which can reference these international standards as touch points. They can do so at a broad level, talking about the areas of focus, enabling countries to draw upon these standards as best practice, or indeed more specifically if we reference standards that talk about financial flows. And those are probably some of the really shining examples of where standards can actually play an enabling role, taking us back to the WTO's role itself in actually unblocking and creating a level playing field globally. And I actually do think, Rupa, to echo and to channel some of your points too, the other important thing to note in these discussions is that countries like Australia, and indeed, you mentioned, and I will use the phrase the global south, countries of my birth, like South Africa, are net importers of these technologies. So in creating these architectures globally, we need to be really careful that we're actually enabling those people to participate in the global architecture and not creating stifling, as I think you put it, local regulations, which actually in the end do land up impacting on development and do land up impacting on other factors because they create entrenched barriers. So I think we have models there in some of the examples I've cited around privacy, where we can work globally, and companies very much are in that picture, companies like Google and Microsoft, who can then reverse engineer to those standards too. And I think that's something we all need to bear in mind, that there are examples of good practice out there right now, while we might bemoan some of the challenges we all face. And clearly on this call, we'll probably talk about it some length. So I think I probably would leave it there, other than to emphasize that obviously we saw just yesterday with the conclusion of the US and EU Technology Council meeting, a focus on technical standards too. So I think they are absolutely in vogue. I think they can be enablers. And I think we just need to make sure that all state parties revert to recognized international standards before they go down narrow paths of domestic regulation. And if I was to offer my honest views on this platform, part of the challenge there is around awareness of those standards, but part of the challenge too is how you actually take and convert those in a domestic legislative sense. I know there's a joint statement on that front as well. So I actually think that's another issue we probably need to pick up in the next ministerial round as well. So I'll leave my comments there at a very broad level, and I'm sure we will dive into detail on this too.
Thank you very much, Jed. So we'll now turn to Eunice for your comments, in particular on the T20 paper and your views about the biggest hurdles, and also maybe the areas for the greatest potential for solutions.
Thank you, Christine, and thank you for the invitation to be here. It's really good to be back at the WTO. And I feel like, a lot of what I was planning to say has already been covered by Rupa and Jed. But before I go into that, and I think, maybe offer a business perspective on these things, I thought it would be useful to just take 2 steps back, right, to understand what's at stake, right? The internet has really enabled, tremendous new growth and opportunities. Millions of jobs are attributable to the internet. E-commerce, I think particularly, in the COVID times, have been a lifeline for businesses. And a lot of this is fundamentally driven by, digitally enabled trade or digitally delivered trade. Whether this is through telemedicine services or having your groceries delivered through an app. In the US, research has shown that 1 in 3 small businesses reported that digital tools have kept them open during the pandemic. And 40% of these small businesses say that they have been using these tools to find new customers, especially where, like in Singapore where I am now, we're in a semi-lockdown again, right? So international customers become all that more important because your domestic sort of market just becomes open and closed according to the restrictions. So in short, there's lots of potential. But as we've heard, also lots of challenges. So I wanted to offer the perspective of Google as a company that's operating across multiple markets, and just identify 2 key barriers that we see that could potentially stifle the potential of digital services trade going forward. The first, I think, has been mentioned by Rupa, and these are what we call data-related barriers. So if you look at trackers of digital trade barriers that are out there in the market, right? So like the OECD Digital Services Trade Restrictiveness Index, eSight, did one as well on the digital trade restrictiveness. The USTR puts out this annual report on sort of trade barriers that they see around the world. And Simon Evnett and Johannes Fritz from the University of St. Gallen, I think they did a paper recently looking at these 3 indicators, and they did a mapping of what are the key policies and barriers that are affecting digital trade. And one common theme I think that they found was that data-related barriers are the highest form of sort of the most frequent form of barriers that we see when it comes to digital services trade in general. And there's a rising trend of this, as Rupa had also mentioned earlier. And on the ground, how this is manifested can be many ways. From one extreme, sort of government-controlled internet gateways, like the Great Firewall, where basically, sort of there's government control and ability to block access to digital services or to websites. And then also, we also see data residency laws that are popping up that limit cross-border data flows. Right. So, I mean, I think we all understand that, governments do have the right to regulate, and regulation is really important to protect public policy interests, like public health, national security. I think it becomes particularly challenging, especially for businesses on the ground, when governments use restrictive digital policies, including data restrictions, as a guise of protectionism. Whether this is in the form of tilting the playing field, in favor of local players, or sort of cutting out market access to certain digital services that could otherwise have been provided on a cross-border basis. So then this brings me to the second barrier that we see quite frequently, and that is this broader theme of digital fragmentism, fragmentation. Increasingly, there's a lot of debate amongst jurisdictions about, new regulation on digital issues, and this is really important. But we're seeing many of the governments taking on these issues in silos, and when governments make regulations on a cross-cutting issue like that, and they don't think about how their set of rules differ from others or consider, some measure of interoperability. What we end up with is a mishmash of digital regulation, which can really undercut the benefits of digital trade. From a business perspective, there are really three broad impacts that we see of such fragmentation, right? On innovation, as well as on delivery of services. First, it will really impede companies' ability to provide customers with the same experience of products and services across all geographies. Useful innovations will become less accessible and less effective, and new products will become harder to launch and scale on a fragmented internet. It can also lead to inconsistent protections for customers. I think there was a quote in the New York Times recently about how a patchwork of rules would give people different access to content, different access to privacy protections and freedoms online, depending on where they are. It adds significant costs, and it also makes it really much harder for businesses to sort of offer their services across multiple markets. In some cases, it may even change the economics of whether a product can reasonably continue to be offered in that market, right? Especially for smaller markets, where the cost of compliance may sometimes outweigh the potential gains. So this actually is something that I think people don't talk so much about, but it effectively tilts the playing field unfairly in favor of larger markets, right? Because the cap basically for smaller markets then becomes the size of your market. And if your regulations are so divergent from international standards or best practice, then I think it becomes a lot more expensive for businesses to invest and offer their products in your market. The second observation is that such divergent regulations really also make it harder to build globally competitive businesses. And this would hurt early stage companies and small businesses disproportionately. So it's one thing for a company like Google to master resources to comply with the different regulatory requirements across markets. I mean, already for Google, we have to hire so many people just to make sure that we're compliant with the local law. But I think if you think about a telehealth startup or a telemedicine startup, it just becomes so much harder, right? When you're a 5-man operation to be keeping track of these constantly changing regulations that are popping up, by the week, and have that kind of same opportunity to scale and to compete globally. So you see that that there's a disproportionate impact on smaller businesses. And finally, there's a broader impact on innovation. such fragmentation really limits the ability of digital services providers to engage in cross-border research and innovation. The exchange of ideas that's needed to develop new technologies, to create new products, to improve existing products, and especially for emerging technologies like AI and machine learning. Open data sets, right, with global representation is so important. Without these data sets that can, that necessitate, cross-border data flows, it would be so much more difficult to create solutions to some of the major global challenges that we're facing, right? Like climate change, like global health equity. So in this context, I really applaud the T20 paper because I think it hits the nail on the head on many of these recommendations. I think some of them are really, really helpful. So I think for one, participation in digital trade agreements, right? Whether this is at the WTO, JSI level, or plurilateral agreements, at the regional level, like in the DEPA agreement or the Singapore-Australia agreement. I think this really helps to provide a useful framework, to promote interoperability that's much needed in terms of, making sure that there is an ability for businesses to be able to operate with ease across borders. Second, I think this recommendation to collaborate on international standards, to develop standards and frameworks that can be applied across jurisdictions, I think can also be very, very helpful to reducing the kind of fragmentation that we see. And finally, regulatory cooperation, and I think promoting good regulatory practices on digital regulation, I think are very, very helpful recommendations that would really help to mitigate some of the challenges that we're seeing today. So I'll stop here and happy to talk and address questions later. Thank you.
Thanks very much, Eunice. You really covered a lot of ground very usefully, particularly in terms of getting into the T20 paper and the discussion of gaps and recommendations. I now want to turn over to George for your views, having heard other speakers, but also your own comments on the T20 paper recommendations. George.
Thanks, Christine, and really great to be here and physically back in the WTO. I feel very, very privileged this week. So I think really building on some of the points that Eunice made, I think, starting off with some numbers, because that's always a good way to start off the presentation. And so we did this survey back in June surveyed 450 international businesses on what their own trade capabilities were and really what types of trade issues that they were concerned with around the world. And it was striking that 2/3 of businesses that we surveyed were actively concerned about technological disruption and changes to the regulatory environments in which they operate. So they can be concerned. So are they equipped to deal with those issues that they're facing? And 48% of them said that they do not feel equipped to deal with the technological disruptions that they are experiencing around the world. And that's really striking because these are the larger companies that we were surveying. So if you're talking about SMEs or even MSMEs, what hope do they have when they don't have, a dedicated data protection officer, that they don't have a team of sort of trade compliance officers in order to make sure that they are actually able to trade internationally? And I think the reasons for this feeling not equipped was striking. And the two main reasons that the companies cited was really a fragmentation of capacity within their own businesses. So these are quite often the types of trade barriers for the digital economy that they're facing are sort of multidisciplined, that there's a role for the legal office, there's a role for the trade compliance officers, as I said, the C-suites and those running the business need to be involved as well. So unless you're able to bring all of those quite, diverse skill sets together, you're not really going to be able to address some of the issues that we're talking about. The other issue that the company cited was really the fast-moving nature of developments around the world, where we are seeing individual economies, moving forward with their regulatory efforts, as sort of every panelist here has mentioned, not always in a coordinated way, and staying on top of those developments can be a real challenge. And I think, you know, that's really important when we're talking about innovation in for service providers, because at their heart, what are service providers? What are the two sort of main components that they have when they're, you know, offering, you know, a particular service? It's their people and it's the data. At the heart of every service provider, those are the two core components which enables them to deliver meaningful services, whatever they may be. So if you're sort of handicapped by having half of what you need in order to provide a service being restricted in terms of how you operate between countries, that really is going to impact how you scale internationally, because where we do see the most innovative service providers in the world, they are in the fintech space, they are in the trade tech space, they're in the med tech space. Everything needs to have tech after it, as we know. But you know, these are places where we are seeing very innovative and exciting service offerings being developed, but they're not necessarily able to scale internationally for the reasons that we've discussed. So coming to the T20 paper, and I would really recommend everyone have a read of it. It's not too long as well. I think, you know, it's not hundreds and hundreds of pages. It's nice, short, succinct, and sort of gives three main recommendations, which Eunice mentioned, but, you know, develop a common regulatory framework is essential in order to enable digital trade and e-commerce, assuring data access. You know, they don't shy away from saying that there are tensions between the free flow of data and privacy, and how do we address that in order to protect clients and consumers. You know, that is at the heart of what we need to be thinking about. And then the final recommendation was addressing the high risk of market concentration and reduced competition. Again, really important for companies as they're looking to scale, that they're actually able to compete on a level playing field with more established players. Coming to the role of the WTO, I do think that there is a huge role for the organization. You know, the existing rules certainly aren't something that are working for all companies. Yes, we have, you know, certain provisions in the GATS, we have certain provisions around intellectual property, but they really are quite distinct and diverse in terms of how they're structured. And they really don't reflect the modern way that a company operates, because most manufacturers now even don't consider them just doing goods trade, because they'll be monitoring the data that's being outputted by a particular widget, or they'll be offering warranty services, or in order to repair that particular product, they'll need to be moving maintenance staff around the world and making sure that they're actually able to offer, you know, whether it's installing, maintaining, or eventually removing and replacing a particular manufactured product. So this distinction that we do have in the WTO no longer recognizes the reality of the international economy, where I would argue increasingly every company is becoming a service provider in one way or another. But the WTO really isn't the only place that we need to be talking about this. We need to be joined up across the board. I think, you know, the work that UNCTAD's doing with the E-Trade for All initiative, it's been, you know, really positive over the past couple of years, because a lot of developing countries in particular haven't even started to think about what the regulatory framework should be for the digital economy, and helping them to think through the various policy options in order to enable their own companies to trade internationally, but also to protect their consumers at home as well. I think that's an incredibly important thing that needs to happen. And, you know, I could reel off a list of acronyms around Geneva of sort of the alphabet soup of international institutions, but, you know, it really does need to be a joint effort where the WTO has a role to play in thinking about how do we govern from a rulemaking perspective and a norm setting perspective the rules of digital trade and e-commerce. But that's not to say the WTO is the only one involved in this conversation. Just my final point, and sort of speaks to the increasing complexity of addressing some of these issues around international trade, is that it's bringing in players from the domestic environment that have never really had to think about the trade aspects of their work before. I know Jed mentioned this, but those regulator to regulator discussions are not something that even trade departments have really had to think about in the past. They're not used to having to deal with their competition authority in any meaningful way, with their sort of information control office or data protection office, whatever a particular jurisdiction is called. We're bringing in many more players into that international trade debate. And I think that, the more that we can do that in a structured way, in a meaningful way, is something that would be, I think, beneficial, not only to the discussions here at the WTO, but taking those trade discussions out to the other organizations that I mentioned earlier. Thanks, Christine.
Great. Thank you, George. So I believe we have a number of questions. So just in the interest of time, maybe we'll.
How about I pull them up, and
Okay.
I know you've got a couple follow-ups for.
Right. So let's go to some follow-ups, and then we'll try and see if we can address some of the questions from the audience. Just going back to maybe pulling things to a more practical level in terms of ongoing initiatives and how some of the gaps might be addressed. And I address this question to all the panelists. It would be interesting to hear your collective views on the most important disciplines in your mind that you think are being negotiated in the WTO GSI on e-commerce. What do you think is missing? The obvious one that we've just heard from Jed and others on is services standards. But again, what do you think is most important, and what do you think are the biggest gaps? So let me just really open the floor to all of you.
I'm happy to start. So in terms of importance, I think that there's three. I think so. The first group, I think, would be the data-related provisions. As we've seen, most of the barriers are in the form of sort of data flows across borders. So any disciplines on cross-border data flows or on data localization would really speak to that. I think particularly, if the WTO can find a way to bridge differences between the different regimes, that we're seeing in the world in terms of data governance. I always like to use the example of, adapters, right? Like electric sockets. We need to build more of that, right? So that, wherever you go, you can plug and play your devices, even though, you may be using a 3-pin plug or like, a 2-pin plug in the EU to each other, and to interconnect in some manner, and to allow the data to flow, between jurisdictions. The second one would be the e-commerce moratorium. I think it would be a really great move forward for the system if a significant group of countries in the GSI are able to agree to a permanent moratorium, rather than have that kind of uncertainty. To be honest, for businesses, I didn't realize how impactful this was until I moved over to the business side, right? That actually every 2 years, businesses are looking and waiting with bated breath, right, to see whether the moratorium will be renewed, because it does have practical implications for us here on the ground. So if you can have a significant group of members in the WTO agreeing to a permanent moratorium, I think that would also change the dynamics in terms of what is discussed at the multilateral level. So that's the second bucket, and then the third is really something that maybe is not so sexy, but actually really also very important, and this is the open government data provision. So standardization of sort of open government data sets, I think can really help to spur innovation and to allow people to come up with new products and services that would be useful, to a global audience. So this is something, I think if we can have some type of discipline on this, and to have some guidance on, like what standardized, open data sets look like, that would be really, really helpful for innovation. And then in terms of what's missing, agree completely on service standards. I think there needs to be some work done there. But the other piece, I think, particularly in today's context, is this piece about SME cooperation. So you see this provision on this in the DEPA agreement, and also in the Singapore-Australia agreement. And this is really revolving really about information sharing, transparency, sharing of best practices. And I think if there is some type of a discipline on SME cooperation or some kind of provision in the JSI, this would also be able to connect the dots between what's being done in the JSI for mismeans, and to pull that together as well. So these are some of my thoughts in terms of what's valuable and so what's missing.
Thank you, Eunice. Others, Rupa?
Yeah, so I actually would concur that data-related provisions, the e-commerce moratorium, at least if not a permanent, a longer moratorium agreed at one go would be better. On the standards issue, I think that's perhaps one of the most important. There, I would actually suggest that there need to be the principles, which are there for technical barriers to trade to be made applicable here on standards. So there could be different standards, or ideally, you should align with existing international standards or try to adopt those. But even if not, the principles that are applied in the case of goods with the TBT, similar principles should be extended in the case of digital services trade. I think so. That's something. I think also the JSI on services domestic regulations, many of the principles there should carry over in the context of digital services trade as well. So non-discrimination, transparency, not being unduly burdensome. So I would suggest, it would be difficult to arrive at some of the substantive elements, but at least in terms of the principles underlying the application of measures, there should be much more progress on that. And I would also go with, the work on MSMEs, because I think there needs to be far more discussion regarding capacity building in countries on exchange of best practices and linking SMEs into the digital markets, because there is a work program on that and perhaps not enough has happened in that area. So that would be my suggestion. I think separately, there is the whole context of GATS. There needs to be progress there in terms of market access commitments, some of the reference papers, some of the regulatory principles there. So I think there is a complementary piece there from the GATS side also that needs to move along with whatever happens in the JSI. Thank you.
And I would just concur with all of those comments. We've gone through a long list, I think, in our session just there, which was really useful. In terms of the moratorium, also to be constructive, the current 2-year window, why don't we look at something that's more 4 years, or be a bit creative around how we meet that midway point? So I put that on the table just to echo the comments that both Eunice and Rupa have made. I love the suggestion as well, Rupa, about the TBT language and actually codifying and maybe bedding that down, because I think that is something that people are struggling to grasp, to speak frankly. And I think that's an opportunity, as you said, not to be prescriptive about the particular types of standards and things, but to talk about the discipline we need around, in the true sense, that is, around how we apply that at a national level. And I think we can actually see gains then globally, which is really encouraging. On the SMEs point, completely agree too. That's a global issue, a global challenge for us. And I know we might come to capacity building in a second, but something I strongly echo, because we see it as a gap, even in countries like Australia, where there is that uplift we need. And so absolutely second those points.
Thank you, Jed. And that directly relates to one of the questions we received from the audience. And that is, should we be talking about a TBT for services, or should, and let me just pose to the panelists, or should we work on trying to get some principles laid down in the context of the JSI on e-commerce, since it's certainly directly relevant? Digitally enabled services are very, very relevant to what is being addressed in those negotiations. So let me open that up to the panel.
I'll go first here, shall I?
Yes.
So I think certainly in terms of the JSI, that is a important conversation that I think we need to have. I would also say that some of the provisions in the recently published domestic regulation talks actually goes a long way into how do you govern your services economy, not saying that you have to abide by XYZ standards, because sort of as the TBT agreement, it doesn't do that, but it does set the guardrails for if you are going to implement regulation on your service providers, you need to be thinking about transparency. You need to be thinking about how do you, what licenses do companies need, et cetera, et cetera. So I do think we have an excellent starting point for that discussion around sort of a TBT for services between the domestic regulation talks and also the e-commerce ones going forward.
Thank you. Any other thoughts? If not, I know our time is running short. I do want to loop back to the capacity building point, and it's something that Rupa brought up in her opening remarks, and I think it's a very important one, and we've alluded to it in the discussion from various panelists' comments. But it also relates to a question that we've gotten from the audience on how do you empower developing countries to participate rather than, and rightly or wrongly, having the feeling that services or other standards are just being imposed on them. And clearly, the starting point is that exercises like the JSI are open to any WTO member, so participation is certainly open. But I think there's a trust issue and a how do you encourage greater participation issue. And so one piece of that might be more work on capacity building. But I really open that question up more broadly to the panel.
I'm just mindful Rupa
Jed?
might want to lead with comments on this given earlier commentary, but I'll go in there as well. I just did have a point too. It's interesting framing the question about developing countries, because actually, as I was stating before, the situation when it comes to many digital services is it's actually quite an even playing field in terms of where many of us are positioned anyway as net importers. So I did want to raise that as well, that actually the way we might view capacity building is ourselves working together, particularly in the standards world. And Australia has done this most recently in terms of working with regional partners around standardization, where we're actually all coming to the party and we're all coming to the table literally together. And the work we're doing is very deliberate around building institutional muscle and memory so that we can negotiate in those countries in the region who might not be at the table currently participating and actively shaping what those standards look like. We can shift that picture. So I think there's a few practical examples there, but I also do think it's not just a case of the global north and south. I do think in the digital realm, there are dynamics that exist which actually challenge some of those notions as well, and that you have highly developed countries which are in similar situations in terms of how they engage with digital technologies and data flows across borders too, both as senders and receivers, if you will. So I'll leave the comments there, but I think there are practical models to underscore that point where we can build best practice knowledge sharing and really get down into detail about how we do that as a global community in a way that actually works for countries. And as they say, a rising tide lifts all boats.
Rupa?
Yeah, so actually, I think I'll go back to what was said by the very last panelist, which is really about the bodies within the countries themselves sometimes not being aware. And I think it has to start there in terms of the capacity building and just awareness of the issues and how the work that they're doing within their silo ministries or agencies has a bearing on digital trade. So I'd start with just creating more awareness and understanding the regulatory implications of what they do domestically on cross-border trade, digitally enabled services. The other is, in terms of just digital literacy, skilling, and connectivity issues. And those are, again, largely domestic issues. But I think, again, there is a lot of scope in terms of learning from good experiences of other countries, exchanging best practices. And the third thing I would say is that countries need to sit at the table rather than being ostrich-like in a way, because that's the only way they can shape the dialogue. And one of the things again, maybe it's not just a North-South issue, but yes, there are large markets in the South, and they need to understand that their role in the digital economy comes both as producers and as consumers. So that realization, perhaps, I mean, they're just seeing themselves as the importers, but they're potential exporters as well. And that awareness raising is very important. That is the way to engage them more, that they have as much stake in it and they need to shape the rules, because tomorrow they might be the digital players as well.
Well, with that, Rupa, I know our time is up, and I want to thank each of you, to Eunice, Rupa, Jed, and George, for your excellent presentations. I think this was a really very important discussion and appreciate your participation. And thanks to the WTO for giving us the opportunity to have this event. And thank you all for joining us. Bye. Good afternoon.